I'm Drew Stevenson, and this is a lecture for my administrative law class about the case National Petroleum Refiners Association versus the Federal Trade Commission, or FTC. This is a DC Circuit Court of Appeals case from 1973 about agency rulemaking powers. And in this case, just to look at the little picture I have here on the screen, this is about the regulation that requires gas stations to put those numbers on the gas pumps, like you see in the picture here, 87, 89, 91, that are familiar to most people who drive cars, as well as some of the fine print about how those numbers were derived. So let's look at what happens in this case. So as I said, the case is about an FTC rule declaring that not posting those octane rating numbers on gasoline pumps at service stations was an unfair method of competition, as well as an unfair or deceptive act or practice. And they're echoing the statutory language here. And a lot of there hadn't been a rule about this before, and a lot of petroleum refiners and a couple of trade associations, including the National Petroleum Refiners Association, sued to challenge the rule. Now, the challenge itself, the question on appeal is really only about whether the FTC has statutory authority to issue such rules, not about the merits of the rule itself. Now, the petroleum refiners claim that the statute gives the FTC authority to adjudicate alleged violations of the statute and bring enforcement actions, but not to promulgate legislative-like or codified regulations or rules. And the FTC says that its rulemaking authority is implied by statute. So for my students, you may remember I've talked about at the beginning of the course, my spaghetti dinner story, right? Which is about, does an agency have authority under its enabling statute to do the thing that it's saying that it should get to do? And that's part of what's going on in this case. Is the question is, does the agency have authority to make rules? And the other thing that's going on is the fundamental question about, do some agencies have to proceed through adjudication? In some ways, this is the flip side of the Chenery case decision, where the court said that agencies can make rules through adjudication, and the same with the Bell NLRB versus Bell Aeronautics case. But here, the question is, can they promulgate rules? So let's proceed and see what happens. So the court, just a minute, here's the act. So the court focuses on the statute, and this is the Federal Trade Commission Act, and Section 53 directs the FTC to, quote, prevent persons, partnerships, or corporations from using unfair methods of competition in commerce and unfair or deceptive acts or practices in commerce. So the statute itself sets out a code of conduct and what will count as a violation. And then Section 5B of the Act says that the FTC can accomplish this goal by means of issuance of a complaint, a hearing, findings as to the facts, and issuance of a cease and desist order. So that sounds like an enforcement action and adjudication. It's not completely clear that that includes kind of codified type regulations. So now also note that this isn't just a silly claim by the refiners. The FTC itself had previously taken the position, actually for decades, that it lacked statutory authority to promulgate rules under that language we just read. And they proceeded with adjudications instead, like other agencies were doing at the time, like the National Labor Relations Board and the Securities and Exchange Commission. But as you know, commissions change over time, right? There's turnover, people's terms end and they're replaced by new commissioners, and there's new issues that arise so sometimes commissions change their mind or just change their mind about how they're going to approach a problem. The Second Circuit held that the Federal Trade Commission Act gave the FTC authority to promulgate the trade regulation rules that have the effect of substantive law. The act itself is admittedly a little unclear, but the court finds that because rulemaking would help rather than hinder adjudication and enforcement of the statute, those are clearly authorized. And so therefore rulemaking is implied. Now, I pulled out a quote for those of you who like to highlight in your cases that really captures the court's reasoning here. Our duty here is not simply to make a policy judgment as to what mode of procedure, adjudication alone or a mixed system of rulemaking and adjudication as the commission proposes, best accommodates the need for effective enforcement of the commission's mandate with maximum solicitude for the interests of parties whose activities might be within the scope of the statutory standard of legality. So why are we even studying this case? Well, the case is and gives a nice example of how courts, at least in the 20th century, were pretty easily found substantive rulemaking authority for agencies, even in vague provisions or passing references in their enabling statute. In other words, the courts kind of didn't have a problem when agencies were promulgating regulations, and at least in the 20th century, and didn't take much for them to find that the agency could do that. Now, I do want to talk just for a moment about the merits of the rule. So there is some question, it's a debatable point whether those numbers on the gas pumps actually do anything. So what was going on in this case was, before we had this system of 87, 89, 90 grade gasoline at the pump, gas stations or independent gas stations or chains of gas stations like Shell or Exxon could kind of just come up with their own system. And the concern was that you could go to a gas station and you might be buying lower grade gas. They might be selling you diluted or lower grade gasoline that they were telling you was the best of the best. And how would you know as a consumer? And so there was sort of a public demand and a government demand for, we need to have some sort of standardized system so that you know what you're getting and you don't think that you've just put really high grade gasoline in your car. When they sold you something that's really low grade. And now as a student, you may be thinking, well, that would just be fraud, right? To tell somebody that something is high grade when it's low grade. But we didn't really have a system to regulate what would count as fraud, right? How much is just puffery, and what are the standards, and what would count as a misrepresentation, and so forth. And that's what the FTC was trying to do here. Now, the flip side on the merits is it's really not clear that those numbers tell us anything, right? So they're not straight percentages. When you put 87 grade in your car, it's not 87% octane, right? The fine print tells you the little equation for how they derive those numbers. And for most consumers, it's really not clear how much incremental difference there is between grades and whether it justifies the price difference and so forth. In fact, Consumer Report says that unless you drive a car with a racing engine in it, or a high performance engine like a Jaguar or something like that, it probably doesn't make any difference to the performance of your car which of those three standard grades of gasoline you put in. And so maybe it's actually deceiving consumers to have the numbers, right? You could argue that, because the people will pay more for whatever the highest number is, even though their car, there would be no difference if they had put the cheapest grade of gasoline in. Be that as it may, let's go back to the case. And because the case is really about whether the FTC can make a rule, not whether this is a good rule. Now, what would have happened? Let's talk for a moment about what would have happened if they had lost and the industry had won. Well, a contrary result in this case would have meant that the refiners would each receive individualized hearings for any alleged violation. So every time we would have to kind of go gas station by gas station, or at least chain by chain, and the FTC every time would have to mount a case to show that not having some sort of standardized octane ratings, which of course didn't exist before the FTC created them, that was a deceptive trade practice. And that's going to be hard to do. If we don't have an agreed upon standard, then how are we going to show that they're deceiving consumers when they say our gas is the best in the world, right? Or something like that. So this would have ended up making it hard to prove violations on a case-by-case basis. So maybe that is actually why the refiners would bother litigating and challenging this case to the Second Circuit. They even tried to take it all the way to the Supreme Court, but got bounced back. Because honestly, compliance is not expensive, right? It doesn't cost anything to have the high schooler who works at the gas station go out and slap some stickers on the pumps, right? It takes a couple seconds, and you just that say 87, 89, and 90, and so this is just putting pumps on labels at gas stations. It's not like we have to buy new machinery or equipment or something like that. So perhaps the point here for the refiners is they thought that if they force the FTC into this kind of quagmire of one case at a time adjudications, that it would stymie their enforcement of the statute. And basically, we won't have to worry about enforcement actions because the FTC, every case is too hard for them and they don't get around to most of the violations. On the other hand, maybe it was just spite rather than strategy. So industries often resist new agency regulations just reflexively as a matter of principle. Some business owners just take offense at the notion that some federal bureaucrat can lay down the law about how firms can manufacture or market their products. So if people don't really want anyone telling them what to do, they could sue just as a matter of principle, even if the regulation isn't really going to hurt them or cost very much to comply with or things like that. It's just a matter of, we don't want to start down this road and we're going to fight them tooth and nail every step of the way, right? So that concludes our lecture about the National Petroleum Refiners versus the FTC.